Good afternoon. We are about to commence today's webinar on simple English drafting, or what is commonly known as plain English drafting. I'm Anuruddha Pereira, co-chairman of the Overseas Relations Committee of the Bar Association of Sri Lanka, and on behalf of the President, Secretary, Council members, and Chairman, Convener, co-convener, and committee members of the Overseas Relations Committee of the BASL, I warmly welcome all the participants to this webinar today. We have over 241 registrations for this webinar, and we are informed that those registrations come from several countries, including the UAE, South Korea, Brunei, Maldives, Seychelles, Mauritius, and China. Our main speaker today is Mr. Niru Pillay, senior lawyer from Singapore. Mr. Pillay was called to the English bar by the Honorable Society of the Inner Temple in 1976. He has 2 master's degrees from Melbourne University and from Nottingham Trent University on law and advanced litigation. He was admitted as an advocate and solicitor of the Supreme Court of Singapore in 1978. In 1990, he became a barrister and solicitor of the Supreme Court of Victoria, Australia. He's also a fellow of the Chartered Institute of Arbitrators, UK, and a fellow of the Singapore Institute of Arbitrators. In 1978, he founded Niru & Co. after leaving Drew & Napier in Singapore. In the last 44 years, Niru has led Niru & Co. LLE, which is a firm that specializes in the niche areas of insurance, reinsurance, shipping, arbitration, international trade, and commercial litigation. Niru & Co. LLC also has an associate office in Kuala Lumpur, Malaysia. Niru has appeared in the Privy Council and has many landmark, notable, and groundbreaking decisions reported to his credit throughout his practice. He has also been an adjunct associate professor at the National University of Singapore. In 1996, Niru was appointed as a member of the Singapore Academy of Law Subcommittee on Plain English Drafting by the then Chief Justice, Yang Pang Ho, which was chaired by the then Attorney General, Chan Sek Keong, who later became the Chief Justice of Singapore. Niru has been an active proponent of plain English drafting. He has helped in drafting plain English documents for the insurance industries in Singapore and Malaysia. He has also been invited to conduct various courses on plain English drafting and advanced litigation by the Attorney General's chambers in Brunei and in Malaysia. I would also like to introduce our panelists. Our panelists today are led by Dr. Aritha Wickramanayake. Dr. Wickramanayake commenced his career at the Attorney General's Department and then became the Director General of the Securities and Exchange Commission and was a board member of the Public Enterprises Reforms Commission and the Accounting and Auditing Standards Board. He established Nithya Partners thereafter and was its founding president partner till his retirement in 2021. And then he founded the law firm Heritage Partners, which he leads at present. He has authored multiple publications in the areas of company law and environmental aspects. Our next panelist is Ayomi Alubihare. Ayomi is the president partner of FJ and G. Deserams, a leading corporate and commercial law firm in Sri Lanka, which recently celebrated its 180th anniversary in legal services. Ayomi was called to the bar in 1992 and specializes in corporate and commercial law with a focus on investment and capital markets, finance and banking law, and infrastructure development. She has also been involved in drafting laws and regulations and rules, including the ICLP Arbitration Center rules. Our next panelist is Manjula Sirimanna. Manjula was called to the bar in 1993 and joined DLNF Deserams, another leading corporate and commercial law firm, which is in the 100 Club in Sri Lanka, which was founded in 1898. Manjula became a partner of the firm in 1998 and has continued as one of the senior and leading partners of the firm over the last 21 years, managing several departments and engaging in a diverse practice dealing with intellectual property, commercial and corporate law, employment and labor laws, and all other areas of civil litigation. This webinar is hosted by the ORC, by the Overseas Relations Committee, with the idea to give the participants an introduction to plain English drafting. This is not an exhaustive webinar where we will go into an in-depth study and analysis of the subject, but it is an introduction, and we hope to organize 2 webinar-based workshops to train interested members of the bar on the subject in the not too distant future. I hope you enjoy the presentation and the panelist discussion that would follow. So I would now like to invite Mr. Pillay to commence his presentation.
Thank you, Mr. Pereira. Good afternoon to everyone. Welcome to this session on plain English drafting or plain English communication. Now, plain English is clear, straightforward expression, and we use only as many words as are absolutely necessary. It is language that avoids inflated vocabulary. It avoids convoluted sentence construction. And the idea is to be short and sharp. It has to do with clear and effective communication. Nothing less, nothing more. This is the style of Abraham Lincoln, Mark Twain, George Orwell, Winston Churchill, Bante, and Lord Denning. As you know, Lord Denning was a big proponent of plain English drafting, and you will see that in all his judgments where most sentences are not more than 4 or 5 words. In fact, Singapore's first Prime Minister, Mr. Lee Kuan Yew, was also a great ardent advocate of plain English drafting, and he had this to say to his senior civil servants very early in his political life after reading their writing, and this is what he said: do not try to impress by big words, impress by the clarity of your ideas. The written English we want is clean, clear prose. Critics of plain language come mainly from within our legal profession. They say it is baby talk. They say it is drab. They say it is curt. But that's not true, actually. Here are some criticisms of legal writing. Law books are the largest body of poorly written literature ever created by the human race. This is said by John Lindsay. And in January 1996, after several decades, the Singapore Academy of Law organized a week-long seminar on plain English drafting for the legal fraternity. And I must say, we have taken a lot of strides, and many Singapore lawyers draft very well and draft in plain English in all communications. And the level of plain English drafting has really gone tremendously high. The Sunday Times, after the event, published this under this heading: hitherto obfuscation, hereafter no more. In the English case of Trafalgar House construction, the court criticized the commercial documents before it and said this, and you can see this was a 1990 decision, where the court said they would save much time and money if in future they set out their bargain in plain modern English without resorting to ancient forms which were doubtlessly designed for legal reasons which no longer exist. In fact, in the Malaysian case of Teo Chee Hing, the court also said even title deeds, those most venerated of documents, have been described as being difficult to read, disgusting to touch, and impossible to understand. Why are there these criticisms? Let us first, therefore, clear up some misconceptions about plain English or plain English drafting or communication. The first misconception is the move to plain English involves a change in the established rules of English. I would respectfully say that's not correct. The aim, in fact, is to have a better version of the language. We want to use the existing rules to communicate in a better and more effective way. Misconception 2, plain English involves skimping on details. It is simplified form of the initial material. I disagree, because plain English is not brevity for its own sake. No essential details are in fact omitted. Sometimes a plain English document may be longer, but it will certainly be clearer. Misconception 4 is that it is not legally precise. Again, this is wrong. The aim of plain English is to add clarity and precision. No established legal rules are abandoned and will not be abandoned. If the subject matter is complex, the language explaining it must also be complex. Well, again, this fifth misconception is not right, because the more complex the subject, the more important it is to use uncomplicated language. So why do we bother? The plain English does not result in a different meaning. Isn't it all a waste of time? I will give you some examples of archaic words which are still found in a lot of our legal writings and books, and of course the old English judgments and other judgments that we often cite. These are some of the words. We use ever to declare positively, hereafter, hereby, herein, hereof, hereon, heretofore, hereunder, hereunto, and so on and so forth. Now, I must confess, and I will say this with all humility, I used to be one who also used these words until the early 90s, when I was introduced to this movement of plain English drafting by the late QC Jim Cannon, who then introduced me to Professor Robert Eagleson, who was a world famous figure in plain English drafting in Sydney. Now, since then, and ever since I became a supporter and someone who practices in plain English drafting, none of these words will find themselves in anything that I draft. So later on, you can look at these words that I just shared with you and see why would it become useful or relevant or need to be used. And a lot of them can in fact be jettisoned. In fact, Carl Farnsworth said this, and he is a Citibank lawyer who also is a great proponent of plain English. And he said this of lawyers. Lawyers have two common failings. One is that they do not write well, and the other is that they think they do. But what Farnsworth said is quite true. I refer to a single subclause in a guarantee document that the Australian courts considered in this case called National Bank of Australasia against Mason. The subclause is so long that I have set it out in a number of slides. I'm not going to read through this whole thing, but it is there for you to see. This is the subclause. And if we go on to the next slides, which contain all of this, now you will see that if you read through this clause, you will actually not understand what the entire clause in a guarantee document, an important document, has to convey, because it is long-winded, it is absolutely dense and almost incomprehensible. And after this session, when you get the paper, you can look at it and you will see that that's how badly the clause itself, and this is only a sub-clause, was drafted. Now, what did the judge in the case think? He also thought it was, and this is what he said at page 203 of the judgment. However, the remainder of clause 1.1 must be read. No easy task, consisting as it does of one unpunctuated sentence of over 450 words of small print, which is presented to the reader in 25 closely set lines, each of excessive length. There the resolute and persevering may find, in the midst of much else, the phrase, and whether contingently or otherwise. Because the clause was drafted so badly, the judge could not be clear what it meant. He thought it meant that the customer must repay to the bank the following: all sums which the bank had paid to the customer, all sums which the bank had paid on behalf of the customer. It does not matter in what form the sums in one are paid. It does not matter if the payments in one are made to or on behalf of the customer with other third parties. It does not matter if the payments made in one are not yet due. When the bank makes a demand, the sums are to be repaid with costs. Because the clause itself was drafted so poorly, it caused great difficulty to the court itself. Neither the customer or the court could know exactly what was intended by the clause. In truth, it is harder to write simply than to write in a long convoluted way. As a lot of us know, only a lawyer can write a 10,000 word document and still call it a brief. And this will demonstrate to you what I've just said. So when lawyers write, I think it will be worthwhile that we take into account 4 points. Who is going to read the document? What will the reader have to do with the document? What would be their motivation to read? What knowledge and reading ability will they have? So when writing for or to a client, we could therefore consider 5 questions. Does it convey the client's instructions? Does it answer the client's queries and concerns? Does it fit with other documents, facts, and circumstances? Does it cover the facts and the law? And lastly, does it put across your position clearly? That means your view or advice. Now, in order to do this, I would say that there are 12 rules, and these are not difficult rules, 12 rules in plain English drafting. The first rule is a standard one that everybody knows: organization. I think the first thing that you should do is to organize, think before you write. That means plan the document. And a lot of people make the mistake of not planning the document before you start writing. So the topics will then come out in a logical order, and it is always very, very good to use paragraphs and headings, subheadings liberally, so that it conveys a clear message and communication of what you actually want the reader to know. And you should minimize the use of excessive cross-references. A lot of the references could be footnoted, and therefore it takes away unnecessary distraction. Rule 2, short sentences. And the most exciting plain English drafting in this sense is from Lord Denning himself. Short, simple sentences. And this is a cardinal rule in plain English drafting. writing in short sentences. People write long sentences because they think they should pack related ideas together. And this is the biggest mistakes that we all lawyers, all of us, including myself, do. And that is we add qualifications and modifications to the idea that we are communicating in our written letters or communications or drafting. This is actually not necessary. You can develop the ideas and keep them together by writing well-controlled sentences and paragraphs. The brain has a limited capacity to hold information in short-term memory. If you go beyond that capacity, the information will not be available to interpret the sentences. Experts have said that 22 or 23 words is the maximum we can keep in short-term memory. And I think this should serve as an upper limit. Over the time, I have not been very successful in writing 3-word or 4-word sentences, but I'm getting there. But I can tell you that happily, most of my sentences have come down to 9 and 10 words at the most. There are 4 guidelines to shorten long, complicated sentences. First, you sort out your ideas. There should be a maximum of only 2 ideas in one sentence. Second, qualifications and modifications should be in separate sentences. Third, conditions attached to the main idea should be in separate sentences. And fourth, explanation should be put in separate sentences. What do I mean by maximum of 2 ideas in a sentence? Now look at these 2 examples and tell me which is clearer. The first is, as time is of the essence of the contract, if the borrower defaults in the payment of any installment due to the lender or fail to comply with any obligation to the lender is entitled to demand repayment immediately without further notice, in which event the borrower shall also be liable for costs. That's the first one. Now let's look at the second one. Time is of the essence of the contract. So if the borrower defaults in any obligation, whether in relation to payment or otherwise, the lender is entitled to demand immediate repayment. The borrower must comply and must make the repayment with costs. Now, reading the 2, it must be immediately clear to anyone, any reader, that the second is obviously clearer than the first. A good example is the Sri Lankan Penal Code, section 52. And the punishments to which offenders are liable under the provisions of this code are, we can break it up. Firstly, death. Secondly, imprisonment, which is of 2 descriptions. Either it could be rigorous, that is with hard labor, or simple imprisonment. Third, whipping. Fourth, forfeiture of property. Fifth, fine. So you break up all the ideas in the sentences so that the person clearly understands what is at stake. Now, qualification modifications must always be in separate sentences. Conditions attached to the main idea should therefore be in separate sentences. And if you look at section 87 of the Penal Code, this is a good example of how this should be done. It separates a description of the offense, and the 2 explanations are then provided separately. Let me show you. The explanations are in 2 separate sentences. And the first is, except murder and offenses against the state punishable with death, nothing is an offense which is done by a person who is compelled to do it by threats, which at the time of doing it reasonably causes the apprehension that instant death to that person will otherwise be the consequence, provided that the person doing the act did not of his own accord or from a reasonable apprehension of harm to himself short of instant death, place himself in the situation by which he became subject to such constraint. Now let's look at the explanation, the first explanation. A person who, of his own accord or by reason of a threat of being beaten, joins a gang of housebreakers, knowing their character, is not entitled to the benefit of this exception on the ground of his having been compelled by his associates to do anything that is an offense by law. Now, if you look at those, here are the examples of all the unnecessary words. Instead of saying in the event of, you could replace it by if. Shall be entitled to, you could simply say may. Shall be obliged to, must. We enclose herewith, we enclose. During the course of, during. In view of the fact, you can say because. In spite of the fact, despite. Of an unusual kind, unusual, at the present time, now. But all these unnecessary words, we all tend to use it time and again, sometimes knowingly, but most of the times unknowingly, because that's the style in which we have been trained and educated, and we have been using it. So it will take some time before we consciously start using those appropriate short words, which will then make the unnecessary words redundant. Now, for example, absolutely certain, we could say certain. Advance notice, there's nothing to say advance notice. A notice is a notice. Added bonus is bonus. Close proximity, close or proximate. If not, use the word near. And consensus of opinion, consensus. And similarly, false pretense is pretense. Final outcome is outcome. Past history, past. And plan ahead is a plan. Now, the fourth rule is that we should always try to use the present tense rather than future tense when we draft in plain English, because the present tense tends to enable us to draft in shorter sentences. Look at this. In the event of a failure of X to comply, can be replaced with if X does not comply. X shall be obliged to can be replaced with X shall. If the borrower shall default, can be replaced with if the borrower defaults. We must also keep sentences clear, and that's the fifth rule. Sentences do not become clearer just because they are shorter. That's obvious. And therefore, care must be taken to preserve clarity. We should therefore read the sentences that we have written to check and recheck. And I can tell you that even after nearly 44 years and nearly 27 years since I started in plain English drafting, even now I try to go back onto my drafting very carefully and making sure that it comes down to plain English. And therefore, I spend a little bit more time, but I check and recheck and check and recheck. So the idea is to keep the sentences clear. Now, this is a short sentence. He eats, shoots, and leaves. What it means depends where you mentally place your comma. Does he eat and then shoot and leave? Or is his diet made up of shoots and leaves? Rule 6 in plain English drafting is you must order your ideas within the sentences. Lawyers often have to put across complex ideas, and particularly commercial draftsmen, commercial lawyers who draft very, very important documents, and even pleaders in pleadings have to put across complex ideas, and they have to use proper sentences to communicate. But what happens in particular in commercial documents, commercial drafting or other documents, we tend to put conditions first and end with the main clause. For example, the structure of this is if X and Y and Z and then. Now, where should you put the conditional clauses? I think we have all been used to put it all at the beginning. We usually write condition plus condition plus condition and then the main clause. Give you an example. If I do my homework, I'll get good grades. If I get good grades, you will send me to college. If I go to college, I will graduate and get a job. If I get a job, I might get fired. If I get fired, I could go bankrupt and lose everything. That's why I didn't do my homework. Now that's putting it very simply. The trouble with this is that the reader must plow through the ifs and buts before finding out what the main point of the clause is. That means if you put your conditions right at the beginning and then leave the main clause at the end, the ifs and buts will make the conditions take center stage and leave the main clause less understood and clear. And this can be very, very confusing to the reader. And he will, most of the time, be lost along the way. So it is better to do it the other way around. Start with the main idea and then set out the conditions. And so this would be, if you do A and B and C, then we will do such and such. And in fact, if you see some of the insurance policies that have been used, that have come into use even in Australia and in Singapore and Malaysia and some other countries where they have gone into plain English, it clearly says that you have to do this and you have to do this. If you don't do this, this is what will happen. So there's been a phenomenal change. And that's what we are talking about in ordering the ideas within sentences. Now, which is easier to understand? Unless it rains or I have work or my wife arranges dinner, I will meet you for football. So you see, it starts with unless it rains or I have work or my wife arranges dinner, I will meet you for football. Or is it better to say, I will meet you for football unless it rains, I have work or my wife arranges dinner. So the idea is that the meeting for the football comes in first and then the rain and the conditions come later. This way the reader will know your main point first. You're going to play football, but it's subject to 2 or 3 things that could happen. And he can then understand your conditions and qualifications more easily. Readers find it easier to read clauses in the order in which actions or events happen, that is, in chronological order. Sentences written in the active voice tend to be more direct and easier to follow. The agent, the participant doing the action, is placed before the verb. So the agent will send your receipt next week. The passive. Now, the active voice is always clearer, where you say, I will send you your receipt next week. Your receipt will be sent next week. In the second sentence, who will be sending the receipt remains unknown or not clear. Compare these 2 sentences. The parliamentary committee discussed the draft bill and then debated the crucial issues until late afternoon. Or the draft bill was discussed and then critical issues were debated until late afternoon. The second sentence is in the passive voice. It conceals information. Who carried out the discussion? Who debated the critical issues? Did the same people who discussed one also debate the second? The passive voice often conceals information, and another example is when you compare these 2 sentences. X made a mistake in not providing the information. A mistake was made in not providing the information. The second sentence conceals the identity of the person who made the mistake. Of course, this is sometimes a deliberate tactic and is often used, if I may say with great respect, by politicians and some civil servants when things go wrong. The passive voice is often used deliberately by politicians, as I said, to avoid accepting blame. A classic example is mistakes were made. But who made the mistakes? This remains hidden and is never, ever brought out. Now, so how do you write in the positive? How would you answer this question if your house is uninsured? So how would you answer this question if your house is uninsured? In fact, what it should mean is your house uninsured? And if you answered the question and you said no, it still does not make any sense. So what it should be is the double negative is always confusing. It would have been simpler to just write in the positive. Is your house insured? Instead of asking, is your house uninsured? Here are further examples of sentences written in the negative form. It is not unnecessary to tell the truth all the time. The new disease wasn't non-infectious. He wasn't irresponsible about his duties. Now, I would say that these are very difficult to understand, as you have to add up the negatives and see if the result is a positive or a negative. And here's a real example from a statute. A plan shall not be treated as not satisfying the requirements of this section solely because the spouse of the participant is not entitled to receive a survivor annuity, whether or not an election has been made, unless the participant and the spouse have been married. What a complicated, many negatives. Here's another example, short, but again, hard to understand. The book is not untranslatable unless one is not Hungarian by birth. Now, number 9, the rule number 9 is use verbs and avoid nouns, because information is lost when nouns are constantly being used. So please make your application on this form. Now, make means nothing. You are just to apply. Number 2, a second example, there will be a stoppage of trains by drivers. A stoppage only means that the drivers will stop. Rule 10 deals with the proviso, or the proviso is any phrase that begins with provided that. And this one, most lawyers, most of us know that this is so constantly used. And here's an example. Provisos in legal writing are not necessary, provided, however, that if a writer cannot find another way to express an exception, then the writer shall use a proviso to express the said exception. The proviso I quoted simply means except. The sentence can be rephrased in this very simple, clear, plain English way. Provisos are not necessary in legal writing, except when they cannot be avoided. In the last example, the provision meant except. It sometimes also means and or if. It is always, therefore, better to break one sentence into more sentences. And this is one thing that every one of us can do and constantly keep doing, because if you do this, you are likely to be able to master drafting in plain English. So use except or if wherever it is necessary. The idea can be put across in this way. Provisos are generally not necessary in legal writing, but they can be used if they are unavoidable. Rule 11, use must rather than shall. Shall is no longer, in fact, used in ordinary language to mean must. In normal use, shall is optional. Shall we meet? So if something is mandatory and is required, use must instead of the word shall, which used to be the word that everyone expected us to use because it has been legally defined. Now, of course, there is no rule 12, and so it was unnecessary and I removed it. Now, most of us will admit that once we start thinking of our audience, we will change our writing habit because the reader cannot otherwise cope with the material. For instance, when we write a letter to a client and say, please execute this document, do we think about whether the client understands what we mean? We lawyers know what execute means, but a lot of our clients don't. Virtually everything we write must be read by someone else. Do we ever consider what is the likely impact on the reader? Usually, we don't, because we assume that they do. When was the last time you leant back and in your chair, or you leaned back in your chair after you have drafted a document or a letter and thought, is there a better way I could have expressed that? These words from Aristotle are therefore worth pondering. He that will write well must speak as the common man does, and think as the wise men do. So shall every man understand him. The challenge, therefore, is to reassess the way we write. Unfair? Maybe. But we believe it is a perception held by a large proportion of the community. Let's face it, it's not that the public out at large or the industry or the commercial world actually think that all lawyers write very well. Will Rogers, in fact, once said, the minute you read something and you can't understand it, you can be sure it was written by a lawyer. I would suggest that we could ask ourselves some simple questions. For example, does the document convey the client's instructions? Does it answer the client's queries and concerns? Does it comply with statute? Does it fit with other documents or facts and circumstances? Does it cover the law and the facts? Does it put across your position clearly? So it is my, respectful advice that in order for us to start writing in plain English, it is very, very important to think about who will read the document, what the reader will have to do with the document, what their motivation is, what knowledge and reading ability they have. This is paramount. So in my view, as I said before, it is extremely important before we all write, we must plan the document and make sure that it complies with all the rules that I have just alluded to. When lawyers write letters to their clients and their opponents, memoranda, or when they draft pleadings, transactional documents, whether it's contracts, wills, trust, or bylaws. Only the best minds and the best writers can cut through most of these clauses and these written communications. Writing simply and directly appears easy or looks easy, but it takes skill, work, and time to compose. But don't forget, all of us lawyers are actually fantastic craftsmen. Drafting, for example, is a craft, and good draftsmen actually are equal to some of the best craftsmen in the world. And so if we can do it very well, and if we can draft a document, whether it be a commercial document or whether it is a pleading like a defense or a statement of claim or a submission, I think we could all sit back and take pride in the fact that that document communicates exactly what we want the reader to understand and appreciate. And when you want to do it that way and you want to actually take pride in your crafting and your drafting, it forces us to think plainly on the issues in order to write it in simple form. And I have a theory. I think the reason why Lord Denning was a big proponent of plain English drafting and why he in fact was able to write in plain English and communicate his judgments in absolute plain English language is because of his background. As many of us will know, Lord Denning's first degree was in mathematics. He was a first-class tripos in mathematics. And after mathematics, he then went on to do law. And as we all know, mathematicians, engineers, people who are basically well-versed in the sciences tend to have a logical thinking process in any issue. So when you logically think through something, you tend to think through matters chronologically and simply, and that helps in communicating something in plain English. Because to write in plain, simple English requires breaking down of ideas, logical thinking, and simple sentence construction to communicate that idea or that issue. In fact, I must confess, and I will say with all honesty, that it is more difficult to simplify than to complicate in any drafting or any of the matters that we need to put across properly in any written document. Now, of course, if you write in plain English and write in simple sentences, short sentences, and communicate great, in that strong, persuasive manner, they carry great power and dignity. And God said, "Let there be light," and there was light. You find this in Genesis itself. Now, plain words are therefore eternally fresh as far as I'm concerned. And I think if you start on this exercise and if you get it into your system, I can assure you that you will be very, very excited about the entire process itself. Let me share with you some caricature which will then give you a little bit of a roundup of what I have been sharing with you this afternoon. The first one you will see, I can't sign this contract. It's not written in plain language. We are pro tem experiencing a severe shortfall in product uptake placement due to a negative outlay scenario among our core consumer base. Basically, no one's buying the stuff. And this is really good. Central Subcommittee Steering Group for the facilitation of brevity and clarity of language usage in the user-provider communication interface. What it actually means is formally the plain English group. Thank you. And I hope that this will be a good start. This is just a very, very brief introduction to plain English drafting. I am not someone who is a professor of English or someone who is an expert in the English language, but I have enjoyed going through this journey of plain English drafting for the last 27 years. And I believe that my clients and those who have been recipients of my communications have found it extremely useful. I have had a lot of people who have come back and said the ideas have been put across very, very simply and plainly. Judges have found submissions much more clearer. In fact, judges in Singapore write very, very well in clear language, in plain language. So I think there's a lot of benefit, and you will find a lot of banking documents, insurance documents, commercial documents in Singapore and in Australia and the UK, which have been subject to the plain English movement, have really become much, much easier and much more user-friendly and much more beneficial. Thank you very much. Good afternoon.
Thank you, Mr. Pillay, for that very informative and beautifully presented introduction to plain English drafting. It was very simply presented. It was a brief introduction. I hope that we had more time. However, unfortunately, we had to limit our webinar to 1.5 hours. So as a result of which the introduction was reasonably brief. Now we have our panelists, and the idea of the panelists was to give the Sri Lankan perspective. Where do we stand today in the areas of practice as it exists in Sri Lanka with regard to plain English drafting? We also have 2 questions. We've received several questions. We have time only for 2 questions. So from the panelists, I would like to now invite Ayomi to speak with her experience in the commercial areas of the law and how she sees the introduction to plain English drafting will impact Sri Lanka, and how do you see we can go forward in this area? Ayomi, over to you.
Thank you, and good afternoon, everyone. Our clients and our dealings are with business. Essentially, the readers of our documents are businessmen. And I go back to the core principle of it's important, and this is Mr. Pillay has covered this. It is important, imperative to give thought to who the reader is. I am going to read out from the FJG practice guide note. Please bear with me. Words are the tools of trade of a lawyer. Not only should we choose our words well, but we should also present them well. We should break up what we write into paragraphs, use plain, simple words and sentences. We should avoid using long sentences. If we must have long sentences, we must break it up with suitable punctuation. We must not stop with our first draft. We should consider how it reads and share it with the client only when we are fully satisfied that what is written would be explicit to the reader. So you can see that in our communications with business, this is what we are to follow, and we follow. It is the use of plain English. If you look at the documents that we use with business and we do and prepare for business, simple documents such as the Articles of Association, It is now written in plain English. I remember when I joined the firm over 25 years ago, we had articles of association for 50 years, a collection of articles of association 50 years, and you could see that language had changed from those articles to what we prepare 25 years ago and even now. So I would say that we do draft and we do use plain English. I'm sure there's scope for improvement, but because business is the reader, it has been a change that we have been compelled to make. It is also, again, thinking or keeping in mind with the reader, we have in the commercial field, we have investors who are not always sophisticated corporate investors, but retail investors. Again, if you look at IPO, initial public offering prospectus, plain English is used. And again, keeping in mind the reader. Lord Denning has been quoted several times by Mr. Pillay, and he did say, writing is not about yourself, it's not about the writer, but about the reader. So I reiterate this point. If you compare the commercial documents we prepare for business and for investors with pleadings, I think there is a distinction and an important one. We have pleadings in court matters as well as in arbitration, and given the legal system, it is sometimes necessary to be emotive, to be somewhat dramatic in our presentation, and this is to be distinguished from the business and corporate documents that we draft for corporate matters. So sometimes it's necessary to use language that may not be as plain as you would use in commercial documents. An example comes to mind, a matter between a film director and the census board. The census board had taken out large chunks of a movie because the protagonist, a female, a woman protagonist, was smoking a cigarette. Without giving thought to the impact on the movie, large chunks had been taken out. In the pleadings, we could have used the words parts were taken out, but instead the words used in the pleadings was gouged out, which was important to give the sense and the impact of the change that had been made. So whilst use of plain English is relevant, even in pleadings, arbitration proceedings and litigation pleadings, sometimes there is a need to use language that is emotive, is dramatic, and even sometimes that urges a case in favor of your client. So with those few words, I will leave you to the thoughts of the other panelists.
Thank you, Ayomi. That was a very thought out comment, and you had really gone into the matter and beautifully summarized it to 7 minutes. And now we have Manjula Sirimana from DLNF Decerums. Manju will speak on from the perspectives of a day-to-day practice. Manjula, how do you see, how has your practice, in your experience, in your day-to-day dealings with clients, how would you draw on plain English drafting, the impact of it? Have you had situations where you had to, there were issues or complications where you had to deal with clients, they did not understand what was presented by lawyers? Do you think lawyers will receive this this idea well, this notion of plain English drafting? How do you see this? Over to you,
Thank
Manjula.
you. Thank you, Anuruddha, and hello, everybody. Yeah, Anuruddha, I think Ayomi kind of, dealt with that quite well. I might just comment in the context of our notarial documents. because I believe that they form a very major part of our legal documentation overall. So these, they come in the form of deeds and indentures, as we know, and they have their own specific structure, which has been determined under the common law, and you know, that's there. But interestingly, the style and the form of the English language used in these deeds remain unchanged now for over 100 years. So having compared, like Iomi said, over the articles from over 50 years, and having had a look at the deeds, because when you check a title, you do check title for so many years, and then you see these ancient deeds. And I mean, I'm sad to say there's nothing that has really changed in the language used. Of course, there's Latin terminology, and that was due to the Roman Dutch law influence. So the deeds still largely remain very formal, with very overly formal language, extremely long sentences with no punctuation, and then several words for one point. If I may just show you a few examples. If you could see this deed of gift and operative clause in the deed of gift, the fact of the gift being made in consideration of love and affection, and then the transfer of property, you can see has got in with so many words: in consideration of natural love and affection, which she has and bears unto the donee, and for diverse other good causes and considerations, hereunto specifically moving. The words hereunto and hereby I have made in capital, and flowing from what Mr. Pill has said, they are still very much in use, Mr. Pill, as you can see in our documents. I'll just contrast that with a clause in from a different jurisdiction. Why can't I get to the next? It's a technical. So anyway, I think there is a technical problem. I'm not sure. Anuruddha, can you check why?
I will check on it.
Yeah. But anyway, that's where we are with our documentation with regard to the notarial side of things. And fortunately, we have now, that being the case, Sri Lanka has commenced implementing a title registration system under the Title Registration Act. Am I being heard?
Yes, we can hear you.
Okay. So I'll stop sharing. So we have
Manju, I'm sorry, if you can read out, if there was I think there was a technical glitch, but if you just read out, I think the participants can still gain from it. Okay. On your slide.
No, I can't change the slide to read it. So maybe we can revisit it.
Oh,
but I think we all know where we are with deeds. But with the title registration, of course, it's a work in progress yet, because all areas have not yet been surveyed. But the Act provides for the form of the title registration certificate, which will replace the deed. So the certificate will have a notarial attestation, but it takes a very simple and easy form and is in line with international documentation in that area. So it is, I mean, I had the slide to show you that it is totally understandable in a single reading with all the necessary information that one needs to have for a transfer of a property or gift or whatever. Let me just try again.
Manju, I'm informed that the issue is from your end. It's
But I am able to share the first screen, right?
yes.
First slide.
Yes.
So I am sharing the screen.
Perhaps you may move to the second one and then share the screen.
Anyway, let's see. Unread. But so hopefully, but of course, till that happens, deeds will be the determining legal document for transactions pertaining to land. And but I'm hopeful that because this has been implemented by law, that we can go beyond the judicial precedent, which I am told by many legal practitioners does not allow for a change in the language style used in these deeds. So hopefully we can move on and allow for a more efficient and process of documentation in keeping with international practices in this area. I mean, it won't be without its challenges, but I am sure we can, start somewhere and move on. So just thought I'd share that one with you because that's large part of our documentation, legal documentation.
Thank you, Manju. Manju, can you also touch on the client experience? Now, when you're presenting all these deeds and documentation, have there been instances where clients have either been confused or they could not understand what was being communicated or their own document, because these documents are made on their behalf? Have you had any experiences like that?
Yes, always. I mean, they tell us they don't know what is in it and they're totally dependent on us. So, I mean, if you are a lawyer, I mean, there are instances where the client has actually, been played out or whatever. So it's extremely unfair by a client. And most of them, it's beyond them even to want an explanation on it. They just have complete reposed their trust in us and hope that we do the right thing. You all will always find a picky, one client who will turn up and who will want every word explained, but that is fine, few between when it comes to deeds. I mean, I'm not in that practice, I mean, a lot, but I deal with so many in the office. And so that is the case. They have no idea of what is written, in the document, which is not at all a fair thing. So.
Thank you, Manjula. That was a very, again, informative and very detailed, and you summarized that into a short time. And I again apologize for the time constraints placed on the speaker as well as the main speaker as well as the panelists. Now we have Dr. Aritha Vikramanayaka, the lead panelist who's leading this panel. Dr. Vikramanayaka, we would like to know from you and your thoughts and comments about sort of rounding up what Iomi and Manjula commented on vis-a-vis the presentation made by Mr. Nirupille. How do you see simple English drafting coming to the Sri Lankan foray? Iomi said it's already there in certain areas of the commercial practice. Manju says that it doesn't seem to have changed much in the notarial sector and some of the other areas. So how do you see this transition will happen in Sri Lanka? We have the port city coming up and the government and the people are expecting that there'll be investment coming in. There'll be a new investment culture in Sri Lanka, then this will be facilitated by a large number of expatriate investors, some of whom for sure will come from jurisdictions that practice in plain English workings and in language. So how do you see this transition taking place here? Will it take place here? Will the lawyers oppose it? How do you see this?
Yeah, let me take a very pragmatic view on this. I'm one person who has been advocating writing in simple English for a long time. And that is something that I practice like a religion. in my relationship with clients as well as in my writing. Okay, but there are certain things that you got to understand when you talk about writing in simple English. Writing in simple English, like Mr. Pillay explained, is not an easy thing, right? It is probably one of the most difficult practices that you can adopt, right, when you get into it. It takes years of practice to master, and I've learned it the hard way. You must understand that writing in simple English is not a mere question of writing. To be able to write in simple English, you must have a mastery over the language. You also must have a mastery over the subject on which you're writing on. It is only then and then alone that you can actually sit down and write a thought in simple English. Now we have problems here, right? One of the things that I've identified is the fact that we in Sri Lanka, and I'm sure in a lot of other jurisdictions similar to us, is that we are not groomed to write in simple English. Leave aside writing in simple English, we are not groomed to write anything at all. I'm sure there are lawyers who are participating in this seminar. I want you to ask yourselves, did you ever write for an assignment in high school or in law college? We never did. The only time we wrote something in law college was when we scribbled notes dictated by somebody else or when we answered our questions. Okay, so nobody really thought about legal writing as such. Now, for us to be able to get into simple writing in simple English, you have to create a mindset, a change in mindset, and that needs to start from law schools. You got to change the way law is taught here. You got to make people write papers. You got to make people get into research projects, and you must grade those papers on their merits and not merely tick off boxes. You know, I had the fortune where when I first started studying law, I remember my grandfather, who was also a lawyer, made me read a book called Learning the Law by Granville Williams. I don't know whether that book is still available. That's one thing that every law student should read before they start learning the law. Okay, that will, one of the lessons there was on how you write simple English. And that has stood me good all my life. The other thing that you got to understand is getting lawyers to write in simple English is not easy. It's actually a double-edged sword. Okay, as we in the legal profession, like in other professions, like the medical profession, know, right? Our practices are now going onto the high street, meaning that any person, any layman with an ounce of intelligence should be able to churn out the documents that we're turning out today. Right? So the only way lawyers try to distinguish themselves is by writing in language that nobody else can understand. It's a defensive mechanism. But we must understand that that's not going to last for very long. Right? If we use that as the way we protect the profession or your practice, you're not going to survive. Right? So you need to understand how to serve your client better. You got to understand the law better. You got to develop your other skills. Right? You got to be able to build a relationship with your clients so that they have the confidence that you know something which they can't get online, for instance. Right? So don't think you can hide behind language which the layman can't understand, because that's not going to last. Now, this is not only in our profession, that's also in medicine, and even take religion. Take the church, for instance. I think even they've realized that you got to simplify the processes to survive. Now, one thing we must also understand that is we can't hide behind these legalese forever, okay? Because as Anu pointed out, we are now going to experience a sea change, right? Take things like this. Take things like the port city. Hopefully, if it ever comes about, you're going to find foreign law firms coming into Sri Lanka, right? You're also going to find a lot of demands from foreign clients who are used to a different type of service from lawyers. And unless we are able to adapt ourselves to be able to deliver services that they understand and they appreciate, we will not be able to compete. It's not only FDI. I think a lot of our young lawyers are now engaged, for instance, in outsourcing operations. outsourcing operations require a good knowledge of English and the ability to write and understand simple English. So we need to change. We can't remain stagnant. If we do that, we will not survive. There's one other thing that I would like to highlight in this short presentation that I'm making, and that is, I think we need to look at our legal drafting. Okay, our legal drafting, I'm sorry to say, is horrid. Right? Just compare some of our MIP statutes. Take the Companies Act, for instance, and compare it with what you get in Singapore or in England. Look at the difference. Look at the clarity of language in the English Act or the Singapore Act. Right? Now, when a foreigner comes in and sees the way we draft it, and remember, our drafting is not the only problem, apart from the spelling mistakes, the grammatical mistakes, and the wrong structures. You also got to remember that we've got to then compare it to the singular version, right? So it's an impossible. It's really an impossible task to be able to interpret and apply law in those areas. So we need to get those things going, right? We need to understand what the challenges are and try to change. Again, as I said, I think Mr. Penal spoke. He mentioned Winston Churchill, for instance. Now, Winston Churchill, if you read his biography, you'll see that he's one person who learned it the hard way. When he first started his career off, he spoke in pompous language, right? He soon realized that nobody could understand what he was saying, and he changed his entire style of speaking. Just listen to his speeches and you will see what I mean. Okay, so my point is we need to adapt, and to be able to do that, we need to spend a lot of time doing that. There is a book called The Outliers, which I encourage all of you all to read, right? It says it takes 10,000 hours to master a subject. And it will take you 10,000 hours of hard work to understand how you write in simple English, right? But if you can do it, I'm telling you, you will never regret it, right? Again, I want to tell you I want to leave you one other lesson. It has, as I said, it's a double-edged sword. I remember once I wrote my book on company law, there was a client of mine, an investment banker, who used to depend on me for advice on company law. After he read the book, he came and said, Aditya, thank you for writing this book. I don't need you any longer because now I understand what company law is all about. Right? But that's all right. Right? You have to take pride in the fact that an average man on the street can read what you write and understand it. One bit of advice, one final bit of advice that I want to leave you with is that you have to read. Spend every minute that you have going into the library and reading. And unless you read, you will not improve your English to be able to write in simple English. When I have spare time, I go into the library and read All England reports. Right? Look at the language, understand what they're saying, right? And that is the way you improve your language. And that ultimately is what's going to make you feel proud to be a lawyer. You're giving a service to your client, which the client appreciates for what is contained in those documents. I hope that's useful. I'll leave you at that, Anu. Thank you.
Excuse me, sir. So
Yeah.
you're muted.
Thank you. Thank you. I'm sorry I had my mic on mute. Thank you, Dr. Vikramanayaka, for that explanation and the comment and the work that would be required to put in to and the importance of why we should move in this direction. I want to raise two of the questions that we received. We selected these two. There were many questions. It's not possible to take all the questions. One question has been raised by Mr. Felician Fernando Pulle from the Nigambo Bar. In an agreement where the immovable property or properties are described in several schedules, is it sufficient to describe the property by referring to the relevant schedule, or is it necessary to give a brief description of the property in the body of the agreement? I find most notarial agreements tend to describe the property briefly in the body, whilst they are fully described in the schedule to the document. I would like to pose this comment to the panelists. Manju touched on notarial. Maybe Manju can answer this question, and perhaps Ayomi and Dr. Vikramanayaka could briefly comment on it. The question is it necessary to describe a property in the body of a notarial document which is clearly in detail described in the schedule?
My answer to that would be it is not necessary. If you have a definition for it, use it in the body, and then you have the complete description in the schedule.
I
have
Dr.
seen,
Vikram.
I have
sorry,
seen,
Manjula. Sorry.
No, I have
sorry.
seen deeds like that. I have seen deeds in that form here in Sri Lanka.
I suppose the form of the document and description of property will be dictated to by the provisions in the notary's ordinance, which actually sets out how a property should be described. So if that is done, whether it's in the body or the schedule, I think the provision will be satisfied. If I remember correctly, and this can be checked, there's a requirement to include the description by boundaries in a schedule.
Dr. Vikramanayake, do you have anything to add to that? Okay. The second question we have is raised by a law student. Bear with me. This is addressed to Mr. Nirupille. If plain English becomes the operational norm, the law student is Mr. Anupdin, plain English becomes the operational norm, will statutes and judicial precedents be required to be rewritten? Mr. Pillay, would you be kind enough to answer this question?
That's a very good question. Obviously, the plain English movement itself is not very old. It's now running into a couple of decades, but there has been significant movement in the United Kingdom, in Australia, the US, even in Sweden, and obviously in Singapore and in many other countries now, where the plain English movement has caught on and where English law primarily is the fountain of the law. Statutes have gone into plain English, as Dr. Vikramanayake said. A couple of major statutes in Singapore, for example, have gone into plain English. Even in the UK and Australia, you take some of these, they are so easy to read. It's clearly designed to, to communicate to the, as we all lawyers, we know the man on the omnibus or the man on the street. He is supposed to, we are trying to tell him this is the law. And if this is the law, these are your rights. And if these are your rights, this is the interest that you need to protect. And so how do we communicate that? I am quite sure that in time, there will be a lot more done. And it is definitely an evolving change. Judges have started to write in plain English. Many have taken the cue from people, famous people like Lord Denning. And as I said, in Singapore, we have got judgments written by many, many judges, both in the Supreme Court, High Court, and even in the state courts. They write very, very clear, the judgments are clear. As I said, in the paragraphing, in the way it is structured, and so on and so forth. And as Dr. Vikramanayake said, this is not something that can start with us as lawyers or practicing. It has to start, in my view, at law school, particularly dealing with legal drafting. And I think if you start at law school, we are then being fair to all the lawyers who are coming out as graduates, that they have been trained in legal drafting. And if they are trained in legal drafting as an important subject, you will find that they will actually put a lot of effort from the word go, before they start their pupilages or their training. They are putting their minds to it. And as Manjula and Ayomi said, a lot can be done. A lot of the documents, some of the documents, I mean, for example, what Manjula was trying to share, I think there were some very good slides. Unfortunately, we didn't get the benefit of it. That one particular slide that she showed about the gift, it's an absolutely atrocious Old English. And that's a classic document where all those words, which should not be in a legal document, are still found. But we've got to live with them, but it's our task to try and change them. And so I am, with the law student who's asked this question, I think you have a lot of hope. I've obviously got a shorter runway left, but you certainly have hope. And I think if somebody picks up what Dr. Vikramanayake said, and I appreciate and I really commend him for being so very candid in his views, because really the change must come from us, from within us. And if we don't want to change, and if we cannot change, then there is no point blaming anyone. And if the investors come, the commercial people come, and they want to do business, and if we are not prepared to embrace what is required by them, then we are going to lose them. And in this, I can say that we are very fortunate in Singapore. A lot of forward thinking, a lot of vision goes into this. And, it started with our first Prime Minister. He insisted that his civil servants must write in plain English, because he wanted everything in a clear document, clear ideas, and short, brief documents, so because he was really hands-on. And I think it has continued with many other people and so on and so forth. I think it has got to start at a particular level, and it must seriously be done. So if the law school takes it on, the law college takes it on, then the professionals, and if pupil masters and everyone keep insisting. And as Dr. Vikramanayake said, you got to read a lot, and you got to try to, keep reading. I mean, even after all these years at the bar, I can honestly, with my hand on my heart, tell you that every document, and particularly pleadings or submissions, and even some long advices, I will go through it at least 2-3 times before it is sent to the client or to my opponents. If I'm communicating something on behalf of my client, or if I'm going to file it in court, I will think about it. And now I've learned some new things where judges, for example, and this is where the schedule comes. Judges, for example, like you to keep the written submissions short. And if you got things that you want to rely on, for example, calculations on certain things, put it in a schedule, because they are all intelligent people. They can go and read and understand what you're trying to communicate. But if you try and put everything into the whole document, you lose the reader. And you must also understand they have a lot to read. They have to read mine, and they've got to read my opponents, and they've got to read other cases. Why do we, make it so difficult that after 20 minutes, they have lost interest in your submission, and you have lost the case? I mean, you have lost the captive audience, which is what you're trying to do. And as more and more advocacy becomes paper advocacy, at least in Singapore, you will find that, drafting or proper documents become very, very important. So plain English is going to be a very, very strong, powerful, useful tool, but it cannot be done overnight. It's a learning process.
Thank you. Thank you, Mr. Pillay. So these proceedings will now come to an end, and I would like to invite Mr. Manjuka Fernando Pulle, the convener of the Overseas Relations Committee, to deliver the vote of thanks. It will be a very brief vote of thanks. We are mindful of the time constraints all of you have. So please bear with us. And thank you again, everyone. Thank you to all the participants. Manjuka, you are on.
Yeah, Anuruddha, can you hear me?
Yes, very well.
Yeah, thank you. Thank you, Mr. Pillay. Thank you for taking a Saturday afternoon. I know time is precious, especially your leisure time, which is very precious, and taking off time to share your experience and knowledge on a very topical subject. I was told that a hallmark of erudition is be able to reduce a complex idea into 2 words. I think you have shown by what you said that you actually or have achieved that, and you at least know to achieve that and share that idea with us and the importance of it. I mean, we live in a world where the Supreme Court of England, I think once the judges actually wrap their judgments, or now really say their judgments in some stories so that increase access, understanding of concepts. I think that's important, and most Commonwealth jurisdictions have now made plain all the statutes plain English drafted and made the statutes of the purpose of interpretation. I thank you for taking a time. I also thank Mr. Haritha Wickramanayake for taking time off his busy schedule and sharing his thoughts on plain English drafting. I have seen him, I have read his books, and a pleasure that always been able to understand and make company law and many more things comprehensible to everybody. I thank Ayomi Aluviare for taking time and sharing her thoughts of how FJs deal with the rest of the world and try to make our law more accessible to the rest of the world. I thank Manjula Sirimana for taking time and explaining to us the complexities that challenges she shares because of our language not being plain and simple. And I thank all participants for be contributing and making this interesting and also encouraging us to have more webinars. The fact that 80 people took part, they asked questions, and some of the comments that came in gives us encouragement to do so that people are interested. That gives us enthusiasm to make that we are making a difference. I thank my colleagues, Dr. Asan Gunawans and Anuruddha Pereira for taking their time. I mean, all credit should go to them. I really did not do anything. They put things together. It's Anuruddha's particular pushing that made this happen. I thank his colleagues in his chambers, Mr. Shehan Pereira and Krishan Vijayasurian, Atif Apudin for also helping us. And I look forward to all of you participating in the future seminars we have, and so that we can be encouraged and look forward to your contributions to make. Thank you very much.
Thank you, everyone. Thank you. Thank you. All the best.